And this matter is before the court today on the plaintiff's motion to file an amended complaint. I would invite counsel to place your appearances on the record.
Steve Grimm and Ben Grover for the plaintiff.
Thank you.
Sam Gilbertson on behalf of defendant John Tetzlaff.
Very good. Thank you, Mr. Gilbertson. And Mr. Grimm, this is your motion, and Mr. Gilbertson argues that I should deny it because obviously I still have an opinion and order due out on the his motion to dismiss based on the arbitration clause. What's your argument that shouldn't be subsumed to that?
Well, yeah, he's wrong because this the proposed amended complaint adds the LLC as a party plaintiff and adds a new defendant who received converted money.
The courtroom hearing begins as the judge calls the case forward and asks the attorneys to place their appearances on the official record. Lawyers from both sides introduce themselves, representing the plaintiff and the defendant. The main issue before the court is a motion to allow the plaintiff to file an amended complaint. However, the judge notes that another important motion is already under review. That earlier motion involves a request to dismiss the case based on an arbitration clause. This immediately creates tension about whether the amendment should even be considered.
This is a derivative action brought by the LLC. It is not a member dispute. So therefore, the operating agreement has no bearing. The provision that 12.1 that we discussed earlier has no bearing on this complaint. We had to wait until now to file this complaint because MCL 450.4510 required us to give 90 days notice to Mr. Tetzlaff, which we did, not only to him, but to his counsel more than 90 days ago. If we could have filed on behalf of the corporation earlier, we would have, but we are required by statute to give them the 90 days notice. The argument that this motion should be denied is without merit. If the factual determination establishes that the complaint was filed to harass Liberty Tetzlaff, well, I am sure the court, after a factual development, will award the appropriate sanctions against us.
The plaintiff's attorney argues that the amended complaint introduces critical changes to the case. The new filing would add the LLC itself as a party plaintiff, along with another defendant who allegedly received converted company funds. According to the attorney, this lawsuit is not a simple dispute between members of the company. Instead, it is a derivative action brought on behalf of the LLC itself. Because of this, the lawyer claims that the operating agreement between members should not control the case. From their perspective, the amendment is necessary to properly represent the company's interests.
And I would expect the court to do so if that was the case. And we don't need to get into any more of that because there is a remedy for that. That is not a basis to deny us filing a complaint for this plaintiff who is a brand new plaintiff and has nothing to do with the operating agreement. The court will
Why not
also
a whole
note,
new case then, Mr. Grimm? I guess that begs it. If there is truly at least in your mind, a separate cause of action here, why within this complaint adding obviously the LLC, the corporation, as a party plaintiff, why within the bounds of this, why not file a separate action?
well, we could. And this is what we were faced with. If the court would rather us do that, that's fine. Here was our dilemma on that. We're before this court on this matter.
The attorney explains that the lawsuit could not be filed earlier because Michigan law required a formal 90-day notice. That notice had to be delivered to the defendant before any legal action could proceed. The plaintiff's team confirms that the notice was sent not only to the defendant but also to his legal counsel more than 90 days ago. If the law had allowed it, they say the complaint would have been filed sooner. However, the statute made that delay unavoidable. For that reason, they argue the court should allow the amended complaint.
We could have filed, and if the court directs us, that's perfectly fine to file this as a business docket case. But we wanted to start here because it is in front of Your Honor, and it is basically the same facts and the same transaction. So that's why we brought it here, and we wanted to get leave because it's been more than 14 days since their first response in pleading. So that's where we started with this. But because it seems to me with judicial economy that we would do them both in the same case, because it's this, though it's a new plaintiff and a wholly new plaintiff with wholly new causes of action for that plaintiff, it is basically the same factual development that's going to be done. And so for judicial economy, it seems like to me, all the depositions, the forensic analyses that need to be done would be done in one case. And Your Honor happens to have this case.
The judge listens carefully but quickly raises a strategic question. If this truly represents a separate cause of action, why wasn't a completely new case filed? The judge suggests that filing a new lawsuit might have been the clearer path. The plaintiff's attorney responds that they considered that option. However, since the matter was already in front of this court, they believed it would be more efficient to handle everything in the same case. Their goal, they say, was to avoid unnecessary duplication and keep the legal process streamlined.
Well, I greatly appreciate your concern for judicial economy and efficiency. Those are things that are near and dear to my heart, I know, as along with the other my colleagues on the court here. And I guess it brings me then to my second question. Well, by its nature, it's a derivative action. The LLC itself, of course, is its members, 50-50, these two parties. Why isn't it all sucked into that arbitration agreement as I anticipate the defendant's going to argue?
Well, he has pointed that out in his brief, but the operating agreement, as we discussed before, very specifically talks about a dispute among members, and that member disputes shall be, when it comes to membership interest, shall be subject to that. Now, we've already argued that, but I don't think any reading of that or any law.
The attorney continues by arguing that both claims involve the same set of facts and transactions. If separate lawsuits were filed, both cases would require the same evidence, depositions, and financial analysis. That would mean repeating the same investigative work twice. From the plaintiff's perspective, combining the matters into one case saves time and judicial resources. The judge acknowledges the argument about judicial efficiency. Still, the court remains cautious about mixing separate claims into a single legal action.
That I'm aware of, and maybe there would be a motion at some point that Mr. Gilbertson can bring forth law that says the LLC as a separate entity is somehow a member. There is a provision that we've already argued talking about the membership interests. This is not that. This is the LLC bringing specific causes of action against two defendants that knowingly received converted funds. And we also have an equitable count in this complaint. This has nothing to do with membership interests. This is not a membership dispute. This is the LLC bringing its own motion through one of the members. So
and I guess we're getting back here to something that was a long time ago for me, law school and the law of course, corporations and LLCs. But, of course, that they are these.
Another concern quickly emerges regarding the arbitration clause in the company's operating agreement. The judge points out that the LLC is made up entirely of its members. Because of that structure, the dispute might still fall under the agreement that requires arbitration between members. The plaintiff's attorney strongly disagrees with that interpretation. He argues that the operating agreement only governs disputes directly between members over their membership interests. According to him, this case is different because the LLC itself is pursuing claims.
Artificial persons under the law, and that inherently, particularly in the case of an LLC, it is composed solely of the interests of its members, in that, the LLC, because of its structure, acts only at the behest of the members and, exists solely for their benefit, somewhat like a traditional corporation would exist for its benefit of its owners, its shareholders. How and I guess I haven't seen either side cite a case or anything on the issue yet, but it just struck me that we're talking about that difficult question of labeling here, and that isn't a derivative action on behalf of the LLC. In reality, an action by one of its members, and therefore subject to the.
The plaintiff insists that the company is acting as a separate legal entity. The LLC, they say, is bringing claims against individuals who allegedly received company funds improperly. This type of legal action does not revolve around ownership interests or membership disputes. Instead, it focuses on alleged financial misconduct involving company resources. Because of that distinction, the plaintiff argues that arbitration should not apply. They believe the case belongs in court rather than in a private dispute process.
Dispute resolution clause.
Well, no, for two reasons. One is, with regard to the dispute resolution clause, the court might note in the amended complaint that we have removed the count that talked about the operating agreement. The reason we did that was because the court was concerned, and I think the court said, we were trying to have our cake and eat it too with regard to alleging the applicability and the violation of the operating agreement. We have now determined, when we did the complaint, we were unaware of whether there was a signed operating agreement. The court pointed out that there wasn't one, and we have determined now, through just this procedural wrangling that we've done for several months now, and there's still been no addressing of these facts.
The judge reflects on the complex nature of LLC law. He explains that while an LLC is technically a separate legal entity, it is still fundamentally built around the interests of its members. In many ways, it operates similarly to a partnership or corporation. That raises an important legal question. If a member brings a derivative action on behalf of the LLC, is it truly separate from the members themselves? The judge admits this issue can be difficult to define.
And a redressing of these issues. So what we did was, since it has now been determined that there is not an operating agreement, we have removed that from the complaint, which should render the prior motion that the court has taken under advisement moot.
I see. So your argument is right. If I grant and allow amendment here, the prior will be moot because we'll no longer be an operating agreement world. Of course, we're still an LLC world, and after all, an LLC does require some sort of operating agreement. And of course, I have been presented with two in this case. One that I believe was signed by Mr. Tetzlaff as the sole member, and then a second one allegedly shortly after dividing membership 50-50, but never signed. And in thinking about this since your last appearance before me, Mr. Grimm, it occurred to me that it seems to me that both these
To address the court's earlier concerns, the plaintiff made a significant change to the complaint. They removed the claim that alleged a violation of the operating agreement. According to the attorney, they initially believed a signed agreement existed. However, after reviewing the situation more carefully, they concluded there may not be a valid signed operating agreement at all. Because of this discovery, they decided to remove that claim entirely. They hope this change will eliminate the basis for the defendant's earlier motion.
Parties operated with some degree of success under this operating agreement for a number of years anyways. There is an argument here that they certainly adopted it. Now, whether they adopted all of its terms, thereby or not, or only some of its terms, I think there's probably some room to argue about. But in any case, it appears to have functioned under the operating agreement as a going entity. And now you're saying you're going to take the position that there simply is no valid operating agreement.
Right. The court was concerned about that issue, and you said that, well, because we made these allegations in our complaint, which was the very first filing in this case, we did say there was a violation or breach of the operating agreement. Now, we have determined, as the court just mentioned, there is no signed operating agreement. And the other thing is, if the court wants to get into,
The judge acknowledges that this new argument could make the previous motion to dismiss irrelevant. If the case no longer depends on the operating agreement, then the arbitration clause might not control the dispute. However, the judge also points out that an LLC usually functions under some form of operating agreement. Even if one version was not signed, the parties might still have acted as if it were valid. That possibility introduces another complicated legal issue. The court must now determine whether the agreement was effectively adopted through the parties' actions.
These are all questions of fact, by the way, Your Honor, that I think need to be resolved in our favor for the reasons we talked about last time, because all factual development must be, it's their motion, they must be resolved in our favor. So whether there was a ratification or not, at a minimum, is a question of fact that must be resolved in our favor. But I also think that there can be, if the court wants to talk about potential ratification, the question of fact here is, there was no indication, nothing alleged, nothing pled, that the parties ratified that particular portion being 12.1. And there are carve-outs on the thing. And so, again, we're talking about factual developments here, again, that must be resolved in our favor. And to say now that, well, the corporation might be a member without any briefing on that.
The plaintiff argues that if ratification of the agreement becomes an issue, it should be treated as a factual question. At this stage of the case, those facts must be interpreted in the plaintiff's favor. The attorney insists the company should not be blocked from pursuing its claims simply because of unresolved legal uncertainties. Instead, the lawsuit should proceed so evidence can be gathered. Only after a full factual investigation should the court decide those questions. Until then, the amendment should be allowed.